Ruled that police could no longer collect DNA samples from suspects after arrests without a warrant. But now, Supreme Court Chief Justice John Roberts has reversed that ruling. As Baltimore defense attorney Warren Brown explains, it's a victory for Maryland law enforcement.
It means that they're free to continue to collect DNA upon arrest.
Justice Antonin Scalia worried about government overreach, writing DNA can now be taken if you are ever arrested, rightly or wrongly, and for whatever reason. With this ruling, justices are solidifying DNA as the fingerprint of the 21st century.
You're watching the most shocking and informative LRJ TV news.
I think I'm going to go back to comedy because this whole protesting stuff is not working. Let's go.
As all states take DNA from people who are convicted of crimes, this is the question of whether you can take people once they're arrested but not convicted of a crime. Half the states do this, and the Supreme Court today upheld that practice by a 5-4 vote. Now, what the challengers of this practice said is, you're taking DNA from somebody that you don't suspect of committing another crime. There's no probable cause to think they've committed another crime, so the police don't have the legal standing to get that DNA sample. But the court said today there are two reasons why it is, in essence, a legitimate thing for the police to do. First of all, they said you want to establish the identity of the person, and the DNA is a sure way to do that. And secondly, they said in order to determine whether it's safe to release them on bail, it's good to know whether they have another conviction for a violent crime out there that perhaps the DNA would solve. What the police want to do is take this DNA and check it against the database of unsolved or so-called cold cases. And the Supreme Court said for those two reasons you can do it. Interesting lineup of the justices here. Justice Kennedy wrote the opinion. He was joined by three of the court's conservatives, Roberts, Thomas, and Alito, and then also by Justice Breyer for the fifth vote. The dissenters were Justice Scalia, one of the conservatives, and then the court's liberals, the other liberals, Justices Ginsburg, Sotomayor, and Kagan. So the Supreme Court has upheld this practice, saying it's for all practical purposes, it's the 21st century version of fingerprints, and the police can take them when someone's arrested, even if that person hasn't been convicted.
The dissenters took the view that it's really very different from fingerprinting. For instance, fingerprinting can yield a match right away, and the police, the stated purpose of this type of matching, which is to identify the person in custody, can be met very quickly by a fingerprint match. DNA testing, at least currently, takes weeks or months, and the dissenters argued that, well, it's not really to identify the person in custody, it's to match them against unsolved crimes. When the state argued that, well, this is such a great law enforcement tool. We've solved many crimes, particularly sexual assaults, where there's DNA evidence that's sitting in the database. Justice Scalia at the argument said, well, whoop-de-doo, basically. If you went into everybody's house on a block, you could solve a lot of crimes. If you stopped everybody at a checkpoint and searched them, you could solve a lot of crimes. The point of the Fourth Amendment is to interfere, actually, with solving crimes, at least to make sure the police have a good reason before they search.
I wonder how all of this got started in the first place. Oh, that's right.
Jan Sepich has been fighting for states to pass laws allowing officers to obtain DNA from arrestees since her daughter's murder about a decade ago. She says such a law in her state of New Mexico would have led to a quicker arrest of her daughter Katie's killer.
Ultimately, this is about the truth, and DNA is truth.
28 states and the federal government have laws authorizing the collection of DNA following arrest but prior to conviction. In a decision of 5-4, the Supreme Court ruled the taking of an arrestee's DNA does not constitute an unreasonable search. In his majority opinion, Justice Anthony Kennedy compared the taking of DNA to fingerprinting and photographing and called it a legitimate police booking procedure. Jonathan Franklin represents victims' rights groups who are celebrating this decision.
More crime will be solved and more recidivist crime will be prevented by this technique.
The ruling focuses on a Maryland law allowing officers to take DNA samples from anyone arrested for a violent crime. Alonzo King Jr. challenged the law after it helped prosecutors convict him of rape in 2009. Attorney William Jay wrote the court in support of King.
What we urged the Supreme Court to do was not to accept the idea that the prosecution charging you with a crime is enough to reduce the expectation of privacy that every American walking down the street has.
In his dissent, Justice Antonin Scalia worried about government overreach, writing DNA can now be taken if you are ever arrested, rightly or wrongly, and for whatever reason. With this ruling, justices are solidifying DNA as the fingerprint of the 21st century.
The highest court, the court that is supposed to make sense of all the BS that goes on in all the different states. For the last so many years, this same Supreme Court has passed laws for cops to use excessive force, that passed laws that police can strip search you, do a cavity search and everything on any type of arrest. Now they say that your DNA needs to be on record. And just recently, the FBI changed the term of the word rape to fit with the new times. I mean, if you got a woman who was raped and you don't have a clue how to solve the crime, maybe your ass shouldn't be a detective. That's the problem now. You got all these cops and none of them know how to do nothing. I'm telling you, I cannot explain this. I don't understand it. I don't get it. That you have to take someone's DNA to put it in this whole database. How many people that have been arrested and has been accused of all type of awful crimes because some zealous want to get the big old black expedition police officer, want to plant drugs on people, want to close out cases. This DNA give these cops an extra reason to falsify, to screw people over. This is proof that America is nothing but turning into a third world country. We don't have any rights. This is plain and simple. Police officer can say, you know what, I don't like LRJ. And it might be a hot ass day and I might get some water. Yeah, we got saliva. Take the little saliva and put on the pubic hairs on there. Yeah, here we go right here. We got your DNA on her underwears. We have the DNA right here. It's on file. This is an example of what I'm talking about. This is what I mean by we have to, this shit is, what the hell is going on up in here? I'm you know what? I'm confused for real. I'm like, the court that we depend on, okay, that to protect and serve our constitutional rights. This court is sitting there enforcing laws to destroy us. They're passing so many police. This oh my God, this is ridiculous. I'm getting brain fucked right now. I think I'm gonna go back to comedy for a while. But guys, give me like 3 days off of YouTube because I'm gonna have to really get my mind together for real. I need a break because this is just too much. Also, I want you to comment down below. What would you do if the cops took your DNA and put it in a worldwide database? Oh yeah, rate, comment, and subscribe because you be glad you did. I love you all. Peace. This world is going to shit.